Ladies and gentlemen, good evening. The Asean Law Association does me great honor tonight by tendering this testimonial dinner. I must especially commend Attorney Ave Cruz, ALA Philippine Chapter President, for his persistence and patience in ensuring my acceptance of your gracious invitation. Frankly, I was quite hesitant to accept this rare privilege of being fitted by the best and brightest jurists, prosecutors, and legal professionals who comprise the best and the only lawyers association in the 10 ASEAN countries. I felt thoroughly unworthy of this honor bestowed upon this humble public servant. However, Ave was insistent and would not accept a no, not even a some other time. That is why several of my distinguished Supreme Court colleagues are in attendance at tonight's dinner. We had all to motor for 5 hours from Baguio City, where the Supreme Court is now holding its summer sessions, until the first week of May. On the other hand, this testimonial provides me with a welcome opportunity to renew fellowships with my esteemed friends in ALA. Let me formally thank Justice Leo Quisumbing, a senior member of our court, for all the good things he has said about me. But even if he is known for his objectivity and judicial prudence, he could also become overzealous in praising his Chief Justice. The Honorable Chow Hik-ting, as I said, a former senior justice of the Supreme Court of Singapore and newly minted Attorney General of the prosperous Island Republic, and most of all, President of ALA, has also spoken very kindly of me. His presence at the testimonial dinner tonight gives me added honor, considering that there must be 101 demands of his time in his brand new job. Actually, we should all be going to Singapore next week to honor him with a testimonial dinner. But I remember that because of his hectic schedule last year, he was unable to attend the international conference and showcase on judicial reform, which the Philippines hosted on November 28 to 30, 2005. Thus, for him to make it to this dinner reception, arriving only a few hours ago, says a lot about the intensity of his friendship. Of course, I would like to thank most especially my neighbor, Ave Cruz, for his generous introduction, although it would have been enough for him to state that I have been a great admirer and supporter of ALA. As he said, I was one of its pioneers in 1980, and I am proud to be a founding member also of the ALA Golfers Club. Now, that should tell you how committed I am to our association. In fact, upon my appointment as Chief Justice of the Philippines, and in reply to the generous congratulatory message of Justice Chow, now Attorney General Chow, I immediately pledged to him in writing my continuing support of ALA. Allow me to thank everyone present here today for taking time out. And we are happy that the competition on the other room has stopped. Friends, normally a testimonial dinner is punctuated by a short friendship message from the honoree. Tonight, however, let me go a little beyond the usual appreciation and fellowship talk to dwell shortly on some recent developments in Philippine judicial history. 3 days ago, as most of you anyway know, on April 20, 2006, which is the 4th month of my incumbency as Chief Justice, I was appointed on December 20, 2006 and took my oath on December 21, 2005. The Philippine Supreme Court unanimously promulgated a landmark decision, partially voiding an issuance of the President of the Philippines entitled Executive Order 464. EO 464 blocked the appearance of executive officials in congressional inquiries in aid of legislation without prior approval of the President of the Philippines. In its simplest terms, the decision held that our lawmaking body, Congress we call it, for the, as many of you know, but for the information of our foreign guests, has the right to compel the appearance of executive officials in Senate investigations because the power of legislative inquiry is as broad as the power to legislate. Hence the provisions of EO 464, which allowed the executive branch to evade congressional requests for information without properly invoking executive privilege in recognized instances were unconstitutional. Nonetheless, the court directed that Congress must indicate in its invitation to executive officials the subject matter of the inquiry, as well as related questions, so that the President or the Executive Secretary can properly invoke executive privilege if need be. Without further commenting, I cited that decision because it highlights the interplay of powers in our governmental system. As you know, our current system of government, well, I say current because there are some moves to shift to a parliamentary or federal system like what many ASEAN countries have in place.